We begin our study of constitutional protection for religion with the Free Exercise Clause of the First Amendment. The text reads, "Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof." This clause guarantees the freedom to hold religious beliefs without government interference. However, the protection is not absolute when religious practice translates into action or conduct. This creates the central tension we must navigate. The government cannot regulate what you believe, but it can regulate what you do, even if that action is religiously motivated. Over the course of this video series, we will trace the evolution of judicial review applied to religious conduct. We start by confirming the absolute protection afforded to belief. Then, we examine the historical standards of scrutiny applied to conduct regulation, moving from the strict scrutiny era to the pivotal shift introduced by Employment Division versus Smith. Finally, we will cover the legislative response, namely the Religious Freedom Restoration Act, which established the modern statutory framework for analyzing burdens on religious exercise. Building directly on that tension, we must first solidify the absolute boundary drawn by the First Amendment. Religious belief itself is sacrosanct. The government cannot compel you to hold a belief, nor can it punish you for holding one. This protection of internal conviction is total and immune from any governmental interference, no matter how compelling the state interest might be. Think of belief as residing entirely within a thought bubble. However, the moment that belief translates into external action, into religious conduct, the absolute shield drops. Conduct, such as practicing a ritual, wearing specific attire, or engaging in communal worship, remains subject to regulation under the general police powers of the state. If your religious practice conflicts with a valid law, the government can regulate that action, even if the motivation behind the action is deeply religious. This distinction between the internal world of thought and the external world of action is the critical gateway to analyzing all free exercise challenges involving conduct. Now that we understand the boundary between protected belief and regulatable conduct, we turn to the standard courts applied when religious conduct was incidentally burdened before the landmark shift of 1990. This period was defined by heightened scrutiny, often referred to as the compelling interest test. In seminal cases like Sherbert versus Verner, concerning unemployment benefits, and Wisconsin versus Yoder, regarding mandatory Amish schooling, the Supreme Court established a high bar for the government. If a generally applicable law substantially burdened a person's free exercise of religion, the government could only justify that burden if it demonstrated two things. First, that the law served a compelling governmental interest. Second, that the law was narrowly tailored to achieve that interest, meaning it employed the least restrictive means available. This rigorous standard protected religious practice unless the state could meet this demanding two-part test. This entire framework is the baseline that the Employment Division versus Smith decision would soon reject for most incidental burdens. We now arrive at the seismic shift in free exercise jurisprudence, Employment Division versus Smith in 1990. The court fundamentally re-evaluated its role, concluding that the Constitution cannot require the government to provide religious exemptions from generally applicable criminal or civil laws. The rationale centered on preventing religious motivation from becoming a shield against neutral laws that apply to everyone. Smith explicitly rejected the Sherbert and Yoder framework when dealing with laws that incidentally burden religious practice but are not specifically aimed at religion. The central holding is powerful. If a law qualifies as a neutral law of general applicability, or NGLA, it does not violate the Free Exercise Clause, even if it substantially burdens a religious adherence practice. This decision effectively ended the era where strict scrutiny was the default standard for incidental burdens imposed by general statutes. To properly apply the Smith rule, we must precisely define what constitutes a neutral law of general applicability, or NGLA. This definition has two critical components. First, the law must be neutral, meaning it cannot have the purpose or intent to target religious practice specifically. Second, it must be generally applicable, meaning it must apply broadly to everyone in society, not just a select group. If a law fails either prong, if it targets religion or exempts many non-religious activities while burdening religion, it falls outside the scope of the Smith exception, and strict scrutiny might be revived. Consider a general income tax law. This is a classic NGLA because it is neutral and applies to all earners. Conversely, a hypothetical law specifically banning the wearing of religious head coverings in public spaces would fail the neutrality test, as its intent is clearly aimed at religious expression, thus avoiding the Smith standard. We established that if a law is a neutral law of general applicability, the Free Exercise Clause offers no protection beyond what other constitutional provisions provide. However, the Smith rule is not absolute. There are narrow, critical exceptions where strict scrutiny is revived, even if the law appears facially neutral and generally applicable. The most significant of these is the hybrid rights exception. This exception applies when the free exercise claim is not standing alone, but is intertwined with the infringement of another fundamental constitutional right. For instance, if the government action burdens religious practice and simultaneously violates the free speech clause, or infringes upon established parental rights concerning the education of their children, the court will likely apply strict scrutiny. In these hybrid situations, the government must demonstrate a compelling governmental interest and show that the law is narrowly tailored to achieve that interest. This means that when fundamental rights converge, the protection afforded by the Free Exercise Clause is significantly strengthened, overriding the general deference established in Smith. We just covered the hybrid rights exception, which revives strict scrutiny when other fundamental rights are involved. Now, let's look at scenarios where the Smith rule simply does not apply because the law fails the core requirement of being a neutral law of general applicability. First, Smith offers no shield if the law is not neutral. If the government enacts a law that specifically targets religious practice, even if it seems generally applicable on its face, it is not protected by Smith. The intent to suppress religion immediately triggers strict scrutiny. Second, consider situations involving exemptions. If the government voluntarily creates a system of exemptions for secular reasons, perhaps for hardship or administrative convenience, but then denies an exemption to a religious practice discriminatorily, the law loses its general applicability shield. In both these cases, targeting religious practice or discriminatory denial of exemptions, the government cannot rely on Smith. The law must then satisfy strict scrutiny because it is either not neutral or not generally applicable in its application. We have seen that the Supreme Court's decision in Smith significantly narrowed the scope of free exercise protection under the Constitution for generally applicable laws. In response to widespread criticism that Smith unduly diminished religious liberty, Congress stepped in. In 1993, Congress enacted the Religious Freedom Restoration Act, commonly known as RFRA. RFRA was designed to restore the compelling interest test, essentially bringing back the standard used in cases like Sherbert and Yoder, but applying it to federal government actions. It mandates that the government cannot substantially burden religious exercise unless it demonstrates the action is the least restrictive means of furthering a compelling governmental interest. Crucially, RFRA, as originally passed, only applies to actions taken by the federal government. This distinction between federal and state action sets the stage for our next discussion, where we will examine the specific statutory test RFRA imposes and the Supreme Court's subsequent ruling on Congress's authority over state laws. We now turn to the specific statutory standard mandated by RFRA. As established, RFRA requires that if a government action substantially burdens religious exercise, the government must prove two things. First, that the action furthers a compelling governmental interest, and second, that the action is the least restrictive means of achieving that interest. This is the strict scrutiny test, effectively overriding the Smith decision for any covered governmental action. However, the critical question arose immediately: could Congress use RFRA to impose this standard on state and local governments? The Supreme Court addressed this directly in the landmark case, City of Boerne v. Flores. In Boerne, the court struck down RFRA as applied to state and local governments. The court held that Congress exceeded its enforcement power under Section 5 of the 14th Amendment. Congress cannot simply define the scope of constitutional rights or mandate remedial measures for violations, unless there is evidence of widespread, specific constitutional violations that Congress is remedying. Therefore, while RFRA remains powerful regarding federal action, its reach over state and local laws is severely curtailed by this constitutional boundary. To master the Free Exercise Clause for the bar exam, you must follow a precise analytical roadmap. Start by asking: is the government regulating mere religious belief or religious conduct? Belief is always protected. If it is conduct, the next crucial step is determining if the law is a neutral law of general applicability, or NGLA. If the law is NGLA, the Smith rule applies. There is generally no constitutional violation unless a specific exception, like hybrid rights, is present. If the law is not NGLA, or if the government action is federal, or state action covered by a State Religious Freedom Restoration Act, you must apply the statutory strict scrutiny test. This means the government must show a compelling interest achieved by the least restrictive means. For quick recall, remember this four-step checklist: belief versus conduct, NGLA status, Smith rule application, and finally, statutory strict scrutiny for federal or religious freedom restoration act cases.